Hello, my name is Aya Johnson,
My name is Rogelio Flores.
and the case we're presenting on today is Lemon v. Kurtzman. So, a little background on the case. The Lemon v. Kurtzman case is a landmark for the United States Supreme Court. It was decided in 1971, and it dealt with the issues of government aid to religious schools, particularly like violating the First Amendment's Establishment Clause, which we'll get deeper into later on. But basically, the case originated in Pennsylvania and Rhode Island, where the states has statutes providing financial assistance to non-public schools, including religious ones. The assistance came in form of like salary supplements, textbooks, and any other instructional materials for like secular education. So the parties involved in this case are the plaintiff, Alan J. Lemon. He's a father of a student in Pennsylvania school system. So he's one of the taxpayers, and basically a group of taxpayers decided to sue the Commonwealth of Pennsylvania for violation of the Establishment Clause. Chief Justice Berger found the statutes of Rhode Island and Pennsylvania unconstitutional. So the Lemon v. Kurtzman case was in 1971. The Rhode Island Early et al. Versus Decensio case was in 1979. These cases pretty much correlated, and eventually the cases were like consolidated when they reached the Supreme Court. So the challenges was a group of taxpayers challenged the statutes, arguing that they violated the Establishment Clause because they were excessively entangled religion and the government aid, pretty much. After the case was consolidated, the court considered whether the statutes in the case were unconstitutional regarding the Establishment Clause, but in a unanimous decision, the Supreme Court ruled that both the Pennsylvania and Rhode Island statutes violated, and we were given the Lemon test, which we'll get more into, but it kind of set the precedent for other cases that dealt with this exact thing. And I'm going to pass it on now.
Alright, so all of these cases are based off of the Establishment Clause, which is what they believe was violated when Rhode Island and the state of Pennsylvania established the statutes which they had placed. So, for example, we'll explain what the Establishment Clause is first. So the Establishment Clause is a part of the First Amendment, which prohibits the government from establishing official religion or from favoring one religion over another. It ensures that the state and the church are never overly entangled, and it makes sure that it keeps them separate. This is to protect religious freedoms of all citizens, so that maybe they may be able to express themselves in a religious manner for whatever they believe in. And so if laws are passed in any sense that promotes or inhibits any religion, then it would be violating the Establishment Clause of the First Amendment. So with the decision of the Lemon v. Kurtzman case, the Supreme Court came up with the Lemon test, which is a 3-pronged test, which would be able to test statutes, laws, anything that would like to be passed to see if it violates the Establishment Clause. The 3 prongs to this test, first is going to be the secular purpose. So whenever a law, a statute, or whatever it is may be passed, it has to make sure that the official reasoning for the law being passed is to have a secular, reasoning. It shouldn't have anything to do with any religion to enforce one or inhibit another. The primary effect should not be to discourage or boost any other one. So the first one, it kind of sounds alike. The first one is the secular purpose, so it has to make sure it has nothing to do with religion. And then the primary effect is to make sure that it doesn't boost or inhibit any religion. And then excessive entanglement. This wants to make sure that the government and religions are not basically entangled, and so kind of goes to to the point of the first and second prong, which is to make sure that neither religion is promoted or inhibited. So a big case that a lot of people kind of think of sometimes when we're thinking about the Establishment Clause is kind of like, for example, when prayers were taken out of school, why were prayers taken out of schools? A lot of times we wonder these things. This is a case in 1962, which is Engel versus Vitale, where the Supreme Court took into decision that it was unconstitutional for schools to have prayer, even if the students had the option to not partake in the prayers. It was enforcing a religion, and this was violating their right. And the state should never have anything to say about any religion in a public setting. So this is one of the biggest examples of the Establishment Clause.
So summarizing the case, it was a landmark for the Supreme Court pretty much, as we got the Lemon test, and this kind of really outlined criteria for like determining whether the Establishment Clause was being violated or not. And the case emphasized that government actions must have secular purpose, and the primary effect that it didn't waive to either religion or non-religion, so nothing discriminatory and excessive entanglement. So like basically just staying out of anything that had to do with religion in the first place. Basically, to sum up the case, it solidified the principle of separation between church and states in the United States, and they use the Lemon test for all future cases regarding the violation of the Establishment Clause. Now, my personal take on this is that I think I agree with the Supreme Court ruling. As a Christian, of course, we'd want like religion to be like put out there more, because as our job is pretty much to like spread the word. But in an unbiased sense, in like the Constitution, neither side should be pressed if we're following the separation of church and state, which keeps everybody happy in a sense. So I agree that we shouldn't push certain agendas, and that this case really did well in determining the statute that would be followed, whether or regarding any future cases that would question the separation of church and state. I went to Christian schools growing up. We still go to a Christian school now, and I've always had the religion aspect in school, and I can't imagine laws being passed that like gave us secular education instead of what we were like used to having already, like used to going to Bible classes in chapel. And that's my take on it.
My take is very similar. As I said, as Christians, we're called to spread the gospel and share our religious views with others. However, I don't believe it should be enforced in a way where people don't have an option in a sense. And also at the same time, when we look at it from the lens of Mr. Lemon, his point of view, one of his big issues was I'm paying taxes, and these taxes are going to schools that aren't public. So they're private parochial schools, and they're taking taxpayer money to go ahead and enforce a religion that he was in agreement with. And so when I look at it from that point of view, it does make sense, and I believe that it does violate the Establishment Clause, because it's kind of promoting a religion, and so we all should have the freedom to be able to choose and not have something pushed on us in that sense. And so I think I believe his name was Chief Justice Berger. I think he did a great job in his decision making. And the Lemon test goes ahead and puts us in a position where now we know how to test upcoming statutes, laws, or wherever it wants to be replaced. And even just by the first prong, which is it secular, makes it very easy. And so I agree that it was a good decision. And so when we look at it into, further cases into the future, I know that there was a case in 2000, Santa Fe Independent School versus Doe, where, it was a student leading prayer before a football game. Parents called that this was a violation of the Establishment Clause because the school was allowing them to have these prayers, and they found that it was, in effect, in violation of the Establishment Clause, and so they had to remove this policy. And so all these things kind of set precedent, and it makes it a lot easier for us to move forward and make sure that our rights are not violated. so that we can express ourselves in a manner that's free and not limited. So, this is our presentation for today. Hope you enjoyed it.
Thank you.